Good afternoon, Your Honor. Attorney Jason Baltz appears on behalf of Mr. Brandenburg. Both of us appear via Zoom technology.
All right, good afternoon to all of you. I have a probable cause statement here indicating that Mr. Brandenburg was taken into custody on December 31st of 2020 at 12:35 a.m. on the charges of criminal damage to property in excess of $1,500 and second-degree recklessly endangering safety. And I've reviewed the probable cause statement. I reviewed it on Friday morning. I found probable cause to believe the charges were committed and ordered Mr. Brandenburg held on that. Mr. Guerrero, what is the status of this? Is the state going to be filing a...
Well, Judge, maybe if you'd indulge me in maybe a longer statement about this than usual.
Okay.
I think the probable cause statement is generally accurate, although there's been a material change with regard to one of the things that you read, even redacting that or putting it in its now discovered form. I think there's still probable cause for a crime with this caveat. Law enforcement was alerted to this on December 30th by Aurora Hospital. Detective Sutherland really discussed this with one of their investigators who forwarded them an email from the defendant where he gave a statement that he'd removed these vials from refrigeration. He'd done so on 2 occasions. His intent in doing so was to render them inert because he'd formed this belief that they were unsafe, that the RNA method of creating these medications rendered them unsafe. I know that it involved 500 doses. I know that it was approximately 50 vials. I know that some people, or at least I learned that some people had been injected with this substance. I don't know who, I don't know exactly how many, and I submit that those records would be forthcoming from Aurora Hospital in some form, depending on whether or not we need to get additional court orders for that. That's all somewhat in play right now. I know that the defendant was arrested because after the police went to his residence, he was pretty cooperative and fully admitted to everything he'd done. He gave them a full confession that he had done exactly this. His intent was to destroy the medication. He did the things that he was accused of. He was arrested, he was held in custody. The police reports were forwarded to my office this morning. I looked at them, but unfortunately this morning, one key element was then walked back by some of the people who had announced it. The initial reports we'd received from Aurora was that the medication was rendered ineffective. The initial report from the investigator was that when they discovered it had been left out, they destroyed the vials. Shortly thereafter, we learned differently that they hadn't been destroyed, but had apparently been sequestered. So apparently they are out there in a way that we can use them. Aurora followed that up with a public...
We can use them for evidence, or we can use them for injections?
No, use them for evidence, but it's kind of that same tenor I'm about to get to. Okay. That statement was then followed up by some public interviews that officials from Aurora gave that the medications had been destroyed or significantly diminished, that their efficacy had been reduced. This morning, it was that conclusion that was being walked back. And at this point, despite having discussed this with a representative of Moderna this morning, several different email communications with Aurora, I do not have somebody with firsthand knowledge that would be able to come to court and testify that these were destroyed or reduced in efficacy.
Okay.
Apparently, the only way they can discover that or tell us that is if they test them. It's unknown how much time that will take. Fortunately, we have them such that some of them or all of them can be returned to Moderna for that testing. Of course, here's the net effect. You found probable cause for recklessly endangering safety and for a felony criminal damage to property. The value of the drugs were somewhere between $8,000 and $12,000, but that unfortunately all depends on whether they were in fact damaged or destroyed. If they were not, despite the defendant's intent, there is no recklessly endangering safety. You do not have a crime known to law as attempted recklessly endangering safety. You possibly have a crime known as attempted criminal damage to property. In Wisconsin, that would be a misdemeanor. And that would seem to apply at some point in time in the future. So there's a few things that need to happen in the future. Right now, We need to get those medications tested. I simply don't know the timeline.
Okay.
I don't know. I believe this defendant has one prior conviction. It's very dated. It looks like it's, I think, a simple possession of marijuana from nearly 20 years ago. I know that I was informed and only received the reports this morning that some of his coworkers at Aurora, only one of whose name I have, represent a report that he had brought a firearm to work on 2 prior occasions. It's unknown exactly when that happened. It seems to be all things that predated this incident. I know that they are concerned about him. I know that when the investigators spoke with Mr. Brandenburg, he expressed that he was under a great deal of stress because of marital problems. He and his wife had separated. He was living in a different address. The police were able to confiscate some of his weapons and hold them for safekeeping, mainly because of his behavior and because of concerns expressed by his ex-wife. Simply at this point in time, what I'm asking the court to do is set a $10,000 signature bond. I think that's about as much as we can do, given it's an attempt criminal damage to property. That's really all the probable cause we have right now. Order the defendant to surrender any firearms, not to possess any firearms, not to work in any healthcare capacity, not to be involved in distribution of any medications to anybody, and to have no contact with Aurora or any employees from Aurora. Unfortunately, the information that we were given at the front end of this case and on which we relied for 4 days, which resulted in this man being held in custody, was walked back and I cannot say is accurate any longer.
Okay. Mr. Baltz, anything?
No, Your Honor, we won't object to a signature bond.
All right. Mr. Brandenburg, I'm going to order you released on a $10,000 signature bond and give you a date further out. Mr. Baltz, I don't have any probable cause to set a preliminary hearing within the 10 days. It's a signature bond, so it would actually be 20 days. While this pens, Mr. Brandenburg, and while you're subject to the terms and conditions of bail set by this court, you are not to work or be employed in any healthcare related function, including serving as a pharmacist. You're not to give any injections or anything of that nature. You are not to leave the state of Wisconsin without court approval. You are not to possess or use any firearms. A firearm includes a pistol, revolver, shotgun, rifle, ammunition. You are to surrender any weapons that you have, any firearms, to the Ozaukee County Sheriff's Department by 5 p.m. tonight. And we'll put this on for status. Mr. Garrow, how long do you think? And then I don't know, all I saw was on the news that maybe federal authorities are also looking at it, or does it look like it's going to be at the state, or is that still up in the air?
I've been working closely with the U.S. Attorney's Office since last Friday. These same concerns are ones that they have also.
Okay.
There's a couple of things. It may be that Moderna is able to get information directly from one of their scientists that provides us with a quick answer.
Okay.
That they've done some testing that I'm otherwise unfamiliar with right now. If that's the case, I'll be able to turn this around in a week or two.
Okay.
If they have to go back and test it somehow, then I simply don't know.
Well, let's put this out a couple weeks. Debbie, can you find a date, please?
January 19th at 3:30.
Will that work, Mr. Baltz?
That does, Your Honor. Thank you.
Okay, so I know any record you have is dated, but so I want to go over what the bail means. You have to honor these conditions, Mr. Brandenburg, or risk being charged with a bail jumping. Do you have any questions on them?
No, sir.
Okay.
Guys, are you ordering no contact with Aurora?
Oh, yeah, you're also not to have any contact with Aurora or any of your Aurora coworkers. No contact means no entering the property, no emailing them, no texting them, no calling them, no meeting them face to face or having a third party do that on your behalf. Thank you.
Thank you, Your Honor.
All right. Thank you, Ms. Carroll. Now we're going back to the regular courtroom, Debbie?